And we will call the first case, Marianne Markel versus Beaumont. This is a 20-minute argument on each side. Mr. Granzato, you know what that means. Whenever you're ready, you may begin. Take your time. I called you fast.
Good morning.
Morning.
Mark Granzato on behalf of the plaintiff appellant. If there is a self-imposed limitation on your asking of questions and comments, I waive it. It's been 44 years since this court addressed the issue of ostensible agency in the hospital setting. It addressed it in a case called Grew back in 1978, and Mr. Grew won the case. As Judge Beckering properly noted in her concurring opinion in this case, as presently applied by the Michigan Court of Appeals, Mr. Grew can't beat the Grew test that is being applied in the Michigan Court of Appeals. The Grew test, as it's been applied in the Court of Appeals, has sort of evolved. It's gained some additional requirements, and as the Court of Appeals decision in this case shows, some requirements that are not to be found in the Grew case itself. I started my brief in this case with a selection of very old cases from this court, some over 100 years old, that address the issue of ostensible agency. And my whole point in doing so is to help you to understand that all we are asking for in this case is that the general rules of ostensible agency that apply in the commercial setting, that apply also in the tort setting, are to be applied in any case involving a hospital. Because what has evolved as a result of the Court of Appeals decisions, particularly the Van Stel case, which is discussed in one of my briefs, what has evolved is a hospital special rule of ostensible agency. There are special rules that now apply in the hospital setting that don't apply anywhere else in Michigan law. And basically, I come before you just asking you to impose the rules of ostensible agency that apply everywhere else in Michigan law to the hospital setting. There should be no special rules. Part of I think the theme of the Grew case itself, there are no special rules for hospitals. And why this is important is because in every other setting, I think I like the commentary from the Dobbs tort treatise on what exactly, in a very pithy way, what ostensible agency is. And what the Dobbs treatise says is the plaintiff can hold the employer to the appearances he has created. That is the very essence of ostensible agency. If you put somebody into a position where that person is perceived by a reasonable person as an agent of the person who puts that person there, that is what ostensible agency is.
Mr. Granzato, let me interrupt you. So how would you advise a hospital who is looking to make sure they can communicate to patients that a physician from another practice who has privileges but otherwise is not on the payroll at that hospital, how would they communicate that to patients? How would you allow hospitals to fit into the general rules that commercial cases and torts cases have for ostensible agency?
Much of the time there need not be any communication, largely because the doctor facing the patient has a prior relationship with that patient. In that situation, the patient knows, it's not should have known, knows that they have not been assigned care by the hospital. By the way, not the situation in this particular case. But in those situations, like Dr. Lonapine faced in this case, the point is communication. That's exactly right. The fact is, if hospitals, because they are, when you have a situation like this case, where somebody reports to the hospital's emergency room, they are getting treatment in the hospital, the assumption, and I put this into my reply brief, I finally went around the country to find you a few cases from around the country. The natural assumption of people in the hospital, when you put yourself in the hands of the hospital, the natural assumption is that person who is treating me has been provided by the hospital. And that's the essence of ostensible agency, what a reasonable person thinks. So if the hospital wants to do something to counteract that natural impression, it's communication. Simple as that. I have seen one case from the Court of Appeals with a form where there's actually an identification of particular doctors in particular specialties within the hospital who are not employees of the hospital, actually a form. That's a little bit dubious in light of the situation in which a patient finds themselves signing such a form. Ms. Markel, for example, was in intense pain. If she had signed such a form, we'd have a very different case. But the fact is, that's one way. But if there was actual face-to-face meeting between a doctor that the patient has no prior relationship with, there must be communication. In fact, that's part of what Grew said. Grew said that and this is really the serious part that the Michigan Court of Appeals has gotten wrong ever since, I think, Ben Stell, and that is ostensible agency can be the product of what the principal does by act or omission. In Grew, the actual word was neglect. The Michigan model jury instructions, by the way, get it correct. They use the word omission. So it is, in fact, in some situations, an omission. That is, the principal is under a duty to dispel the appearance of ostensible agency and doesn't. And for some reason, and I don't understand why, but for some reason, hospitals have not done that. Okay, at least not in the cases that I have seen. Okay, but the point is, if there is a new doctor coming on to treat somebody who has never had a prior relationship with that patient, and the hospital wants to avoid an ostensible agency claim later on, that must be communicated to the patient because of I think it's the Mississippi Supreme Court said in the case I cited. The natural assumption, and it makes complete sense, the natural assumption is if I'm seeing a new face and that person is treating me and I came to the hospital, that person is in fact an agent of the hospital. And they must be disabused of that notion. There must be some sort of communication or else the hospital has to be held liable. And
so let me ask you a different question. I appreciate that answer. That's helpful, and I think the hospitals should hire you to help them. The hospitals should hire you to help them through this situation. But let me ask you a different question. I think you and Judge Beckering read the order in the Reeves case differently. Judge Beckering seemed to think that the Reeves case changed the GRU standard, and your brief instructs us to read it as not very important. And it clearly didn't overrule GRU. In fact, it didn't say anything substantive at all.
Correct.
But how should we think about the Reeves order?
Well, I think what I would say first about it is it couldn't overrule the GRU case, and it didn't overrule the GRU case. I put a footnote into my initial brief. If you drill down deep enough, Judge Hoekstra's decision in that case is, at least in my estimation, highly inconsistent with GRU. This court adopted that dissent, but GRU is still the law. The one sentence or one paragraph, whatever it is, order issued by this court in 2011 is not going to change the holding of GRU. But there is, in my estimation, some inconsistency between what Judge Hoekstra said and adopted by this court and what the GRU court said. For example, the GRU court was not addressed by Judge Hoekstra. The GRU court, citing the Stanhope case from the California Court of Appeals said specifically that agency issues are facts, questions of fact for a jury to decide, not mentioned in Judge Hoekstra's opinion. Judge Hoekstra, I think, also made the note of the fact that the doctor, whose name remarkably to me began with two Z's, I forget the pronunciation, but the doctor involved in that case actually never told the patient that he was, in fact, an independent contractor. Judge Hoekstra, I think, should have recognized that as a pretty clear tip-off to comparison to the Grew case itself, because that was, in fact, cited by this court in the Grew case, supportive of the ultimate conclusion that a sensible agency applied. So the fact is, it couldn't overrule it. If you drill down deep enough, it seems to me, even I would find it to be somehow inconsistent with Grew, but Grew is still the law.
Mr. Granzato, I have a question as well. I'm wondering about, this was raised by the defense and I believe amici, about sort of the reality of how hospitals work now. They have a lot of contract groups under the hospital umbrella. Doctors, I think it's not a secret, are organized into these groups and they contract and they are independent contractors. What do we do with the fact that healthcare requires so many levels? So you have the face as you walk in to the emergency room, but then a report gets sent off to radiology, for example. Radiologists usually are their own group, a different company. A lot of them work remote. They don't even work in the hospital. They might be sitting at home looking at a report, and maybe they mess it up. They don't read it right. What do we do about that radiologist? How do they fit into this?
Well, we're talking about radiologic malpractice when we're talking about it in this context, okay? And quite frankly, there are people who not only have no prior relationship with the patient, they never met the patient.
Right.
And the fact is that it would seem to me that absent some sort of communication between the hospital and the patient, that the natural assumption, the reasonable person standard that really should be applied here, the natural assumption is that the people who are reading these studies are in fact employees of the hospital. Now, maybe, we could have a shift in culture here, that people become more aware of the fact, or you could have a very sophisticated plaintiff. Okay, a plaintiff who actually knows how the hospital works. In that situation, again, there might not need to be communication with respect to the independent contractor versus employee status of these people. But the radiologist cases, I've always thought, from my perspective, are the easiest cases to have ostensible agency, largely because the assumption is I'm getting care. I have turned myself over to a hospital for my care. Whoever malpractices on me is a representative of the hospital. Now, again, there may be some retort to that, but the fact is, absent some sort of communication, I don't know how it can be avoided, radiologists or anesthesiologists.
So given that I know a lot of doctors and hospitals are independent contractors and part of independent groups, can an intake form just have a bold print, every doctor treating you today is not our employee, they are an independent contractor, we're not responsible for them. Would that suffice? That's
a step that could be taken. Again, obviously, all of these agency cases are case by case. The question of whether that is in fact communicated correctly or in a way that actually gets through is something that would have to be addressed on a case-by-case basis. And again, I think I've only seen I've seen some forms that say some of the doctors are independent contractors. But that can't do it because the converse of some of the doctors are independent contractors is, of course, that some of the doctors are employees, and that communicates nothing about the particular doctor, it seems to me, who is actually alleged to have committed malpractice. So The fact is that this is a situation where the law is very clear as to what it takes to have an ostensible agent. And the fact is, if we apply the law that's been developed in this court for literally over 100 years, that is, if you put somebody in the position where a reasonable person believes that person to be the agent of the principal, that is an ostensible agency. That's all that is required. And in this situation, now Van Stel was a slightly different case in which the patient sought care at the doctor's office. That would be a slightly different situation. But in this situation, where a patient is facing a doctor whom she does not know in the hospital, the natural, reasonable conclusion to be drawn is that person is, in fact, an agent of the hospital. As I mentioned in my brief, Beaumont doesn't let Dr. Lanapin walk in off the street. Okay, if she put on a white coat and walked into Beaumont Hospital, but was, somebody other than a doctor, she would not be allowed there. The fact is that this whole idea that has been engrafted onto this by the Michigan Court of Appeals that requires some act by the principal to have an ostensible agency, this whole number of cases on this subject goes by the boards when you're talking about somebody who's facing somebody in the hospital, because the hospital has already done something to make that person appear to be the agent. The hospital has allowed that doctor to be there. Dr. Katzowitz is the doctor who was involved in the malpractice in the Grew case. He was there. He had privileges. He was an independent contractor, but he was there. He had the right to be there. Dr. Lanapin had the right to be here, and she had the right to be there precisely because Beaumont allowed it. So Beaumont did something. The fact, all of these cases that the Court of Appeals has ruled on that seem to say the hospital didn't do anything. Well, Dr. Lanapin is there. That's the point of this.
Does the change in the historical practice at hospitals that Justice Welch was referring to?
Pardon me?
This change in historical practice at hospitals, where we used to be maybe in the old days where people were employees of the hospital, and now very few of them are.
As I said,
Does that change what a reasonable person might expect when they go to the hospital?
It quite frankly could. And you could even have, I'll even grant this, you could have situations, I mean, one of the last lines of the Grew opinion is that there was, the plaintiff neither knew nor should have known that Dr. Katzowitz was an independent contractor. So you could have subjective knowledge. If you had subjective knowledge that the person was in fact an independent
Your
contractor.
client worked as a nurse at the hospital for 30 years or some decades of time.
Yes.
Does she have subjective knowledge as to how the hospital
Well,
operates?
I think that's why they have depositions, it seems to me.
Let me ask a different question. I think what you're proposing here is an expansion of liability. You're asking us to, depending on your perspective, be faithful to Grew or interpret our agency and estoppel principles to expand liability. My question is, from a policy standpoint, if we're thinking about this to change the common law from what has been the law in Michigan, whether it's our case or the Court of Appeals prevailing rule, why is that necessary? Doesn't the doctor have these practices? Don't they have malpractice insurance? Aren't you just looking for another deep pocket? How many deep pockets do you need?
Well, I disagree with the premise of your question.
I figured you would, but in some sense, you're wanting to expand liability, right?
It's
asking
really
for a
not an
broader-
expansion. I want Grew reinstated. That's what I
fine,
want.
fine.
I
I
want
know that's
Grew
your
reinstated.
perspective.
But from a public policy standpoint,
But the status quo is, according to you, too, is that Grew's not been faithfully applied, so the prevailing rule is a more narrow liability, right? And you're asking for a broader rule.
well, broader than the
Question
Court
is,
of
How do you
Appeals.
justify that from a policy standpoint?
Well, from a policy standpoint, number one, there are rules of ostensible agency that apply in this state. Why should hospitals
That's a
have
legal-
special
that's a legal-
rules?
That's a legal argument.
No.
I asked from a policy standpoint,
For-
you're asking us to change the
Well,
status quo in Michigan.
Wait, I'll be very practical, okay? There's a reason hospitals get named for the liability of their employees or their ostensible agents, okay? There's a very clear reason they do.
I get that, but my question is, isn't there already insurance, isn't there already collectible defendants when you sue the doctor's practice, the professional liability, limited liability company the doctor operates in? I mean, does the hospital let doctors operate? Do they grant privileges to doctors who aren't insured?
But your question
Where am I going?
puzzles
Well,
me
tell me.
a little bit.
Why?
But it puzzled me because we've been fighting this case. This happened years and years ago. We're fighting this case precisely because there is a value to my client with respect to the hospital's liability in this case. I don't know what the exact value is, but why should,
I get why you're doing it in this case. I understand what your client's after. The question is from the broader perspective that we're supposed to
Okay.
look at our level. Your client theoretically could be made whole.
Exactly right.
If the doctor was negligent and the doctor has enough coverage to pay for the damages, right?
correct.
So your client, in fact, couldn't get a double recovery at a jury trial from both defendants. Your client couldn't collect twice, right?
Well, I can only
wrong?
suppose what's going on in this case because was not the trial lawyer in this case. But if Dr. Lanapan had millions and millions of dollars of insurance coverage, I don't think I'd be standing here right now. The fact is that my client, I can only assume, will not be made whole unless the hospital stands behind the negligence of Dr. Lanapan. And that's a public policy issue, it seems to me. At least it is from my client's perspective.
I mean, I don't know, I'm like you, I don't know if there was a lawsuit against the doctor and it's settled, but if it's settled for less than the policy limits of the doctor's policy, then that's the question I'm presenting to you. But I think I understand your answer, but I'm just, from a policy perspective, struggling with the idea that if
What-
injured parties can be made whole against one defendant, why we would need to make sure there are two.
Well, from a policy perspective, I guess my question back to you would be, why should there be a special rule for a hospital? They know the rules. The
Well-
rules are if you hold somebody out to be your agent, you're going to be held liable for them. It's been the rule for over 100 years. Why should hospitals, just hospitals alone, why should they have special rules? That's a policy issue, it seems to me.
I suppose.
Thank you.
Thank you, Mr. Granzato.
Good morning, Your Honors. May it please the Court, Joanne G. Haas-Swanson, appearing on behalf of Beaumont. We're here today to discuss whether the Court of Appeals decision in Markel properly applied the GRU test. And plaintiff's attorney agreed on page 8 of his brief that the GRU test is the three-part test that was adopted in GRU. We haven't heard any discussion of that at all so far today. And nor have we heard any discussion of the application of the facts of this case to that test. And the reason is because plaintiff cannot satisfy that test. The GRU test is not what a reasonable person would assume. The GRU test focuses on the particular plaintiff, what the subjective beliefs of the patient are, and whether that belief was caused by some action or omission of the hospital. And Mrs. Markel has testified definitively several times in her deposition. I don't remember Dr. Lanapan. I don't remember most of the doctors who treated me. I don't remember any conversations, except I do remember seeing my neurosurgeon in the ER. I remember something about a pain doctor coming up to visit me to potentially do an epidural. And I also remember some conversations in the ER with some of the providers there about spinal stenosis. So she has some memory. She wasn't totally out of it, but she does not remember Dr. Lonapen and others. So what does that mean? That means, as the Court of Appeals and the trial court held, if she doesn't remember this doctor, she can't form a reasonable belief based on something Beaumont did that this doctor was an agent of Beaumont Hospital. And again, I don't think we should be troubled by that. Because as Justice Viviano, I think you pointed out when you were asking about the policy behind it, vicarious liability is an exception to the rule that each person is responsible for his or her own liability. It was not, ostensible agency is not meant to apply in every circumstance. It's an exception.
Counsel, good morning. I just have to ask you a few questions, if I could, just on the line of what you were saying. And I mean, you're doing a great job. I just have some questions that I think have kind of come to my mind. As you know, I always have an approach that I like to keep things simple. And
I'm sorry, I didn't.
no, my jurisprudential philosophy is I always believe things should be kept simple, right? As simple as possible. And also, I think there has to be a pragmatic kind of approach, like a practical approach in terms of what this does in the real world, right? In terms of how this affects people in the real world. So the question I have for you is, and I'm going to ask you a few, but Beaumont has an entire marketing campaign where the entire campaign was, do you have a Beaumont doctor? And in this situation, if a person goes to Beaumont, especially under your own marketing campaign, I mean, the whole campaign is, do you have a Beaumont doctor? Wouldn't a natural assumption of an individual be that if they actually go to Beaumont because of the marketing campaign of Beaumont, that the doctor is going to be a Beaumont doctor?
Well, my response to that question is it is not applicable to this case. It is another fact, perhaps, for another case. But there is no testimony here that Ms. Markel went to Beaumont because she thought she was attracted by the campaign about a Beaumont doctor.
No, and I appreciate that, but now I have another question for you. Because again, real world stuff, right? So going with what you just said, should there be a different standard? Okay, so in this situation, right, why does that matter, right? So I was a trauma patient myself, right? So as a trauma patient, when you come into a hospital, remember, as a trauma patient, right, why does it matter? Ultimately, if I'm brought in by an ambulance to a hospital as a trauma patient, am I supposed to now, what's the real life implication? Am I supposed to keep track of every physician that has saw me? Am I supposed to take notes? Like, what am I? I'm just giving you from a real life perspective as an actual trauma patient. I'm trying to understand what your argument. Argument doesn't make a lot of sense.
Well, I think you're turning the GRU test around. You are turning it around. It begins with a subjective belief. If there isn't a subjective belief, you don't go any farther, and it has to be created by the hospital. So the focus is on the particular patient. This isn't a reasonable person. It's what happened in this particular situation. And again, even, the example of a trauma patient being brought to the hospital, Ms. Markel those facts don't apply here. In fact, Ms. Markel was at the hospital several days or even up to a week earlier because she had surgery at the hospital administered by her own personal doctor. So it would be natural when in the week following surgery she's experiencing pain, she's going to go back to the same hospital that she was initially treated at. So I appreciate the thought that has gone into your questions, and I appreciate the ramifications that it may have on the rule, but that is for a different case. It is not for this case.
I understand your position that, and that's a point well taken, that if this isn't the best vehicle for speaking to it, your goal is for us not to do anything with it, and I understand that. But humor us because if we're are going to decide this, or we're here and we're hearing this, and obviously we're not just looking at this case, we're looking at how it applies to other cases, right? And if as plaintiff has suggested, the lower courts have sort of gone off on a tangent from what Grew said, how does it apply to somebody like Justice Bernstein was saying, a trauma patient, somebody who calls 911 and doesn't have a choice going in, or someone who is unconscious and goes in because either the ambulance or somebody else brought them in and remains unconscious through, and unfortunately passes away, but suffers malpractice in the context of that? Like, how do you, there just is never ostensible agency if the person is injured badly enough?
There is not ostensible agency unless you can satisfy the requirements of ostensible agency. And that is that the principal has intentionally made a representation. This is my employee. This is my agent. And in the situation you described, it should not trouble us that you might not be able to establish ostensible agency in that situation, because again, it is not supposed to apply in every situation. It's an exception. It is not the rule. And the way that the rule has been described by Mr. Granzato, the exception would swallow the rule. There would be no rule.
Are you saying the hospital doesn't make any representation or doesn't take any affirmative act by providing the individual with a doctor to provide treatment to them?
I think there are, in the situation you describe, and I think if you look at some of the cases, you will see that the treatment of an emergency room might be a little bit different. So I think you have to take that out of the equation of this case as well. Because the hospital does contract with the emergency.
Didn't she present to the emergency room?
Pardon me?
Didn't the plaintiff present to the emergency room in this case?
She did, but her claim against Dr. Lonapin has nothing to do with the emergency room treatment. There are no allegations of malpractice arising out of the emergency room treatment. And if we're going to talk about the reality of the situation, we should consider the ramifications of attaching this type of liability to a statutory requirement that the hospital grant privileges to the physicians who practice within the hospital. It's not something the hospitals dreamed up to do on their own. They are required by the Public Health Code to enter into this privileging process. And the reason is to make sure that the physicians who are practicing in the hospital are practicing within their areas of expertise, are qualified, have the credentials, have the training, and that's why they're privileged in certain areas of practice. Now what plaintiff is suggesting that you do is to burden a statutory requirement that was enacted decades ago with the sudden characterization that this is an intentional representation by the hospital that this doctor is my agent and employee. That simply is not true.
What was the intentional representation in the Grew case on behalf of the hospital? What was it?
I think that it is very difficult for us to resort to the facts of Grew to try to resolve the issue that's before you today, because
I'm just asking you to answer one question. What was the intentional representation in the Grew case by the hospital?
I can't answer that question.
Because there was not one, correct?
I think it's difficult to parse through the facts of Grew. I wish I could answer your question more fully and completely, despite the fact
I
that
think you're answering it by telling me there was not one. Is that correct?
I am saying that we do not really have enough facts to be able to make the determination of
So
that.
there were no facts in Grew that equated to an, I'm not saying, maybe you think Grew is a bad test. Maybe the policy reasons you're arguing might make sense. Maybe the rule from the Court of Appeals that has evolved is one that you think is a better rule. I'm just trying to, I'm stepping back from your case and just trying to understand the doctrine.
Okay.
So
let me try to answer the question. And I think it's been Mr. Granzato's strategy to get you to focus on the holding of Grew rather than the test of Grew.
So I'm giving you an opportunity. I'm asking you to tell me what is the affirmative action, intentional representation in your words, that the hospital took in the Grew case?
Again, I'm not able to answer that fully, because I am not fully aware of the facts. But what I would hope that you will do.
You're not
and-
fully aware of the facts in the GRU case?
I mean, I'm not really fully aware of all of the facts, because the facts are sparse. We don't have a lot of facts regarding GRU, despite the fact that it came after a jury verdict. And what I am hoping that you will do is to focus on the rule, the three-part test of GRU, because that's what we're here. The holding of a case depends on the facts of the case. And each case has different facts, and consequently, the holdings are applied in a different way. But you
Doesn't
can-
the court's application of the facts in a case to the rule that they're announcing in that case inform the rule?
It does, there seems to be, in my view of GRU, which may be my own intellectual limitations, there seems to me to be a disconnect between the facts in GRU and the test that was applied. I mean, I guess I can't say it any differently than that. But what I think that I would propose to you today is that the facts in GRU are not our facts. Our facts are.
Well, that's all, you may win under all your facts, like that's just, but I'm gonna let somebody else figure that part out. We're just trying to figure out, it feels like this has gotten, it feels like Judge Beckering was onto something, right? This question in the hospital setting has gotten a little muddled, and to the extent we can bring clarity, that seems to be what we're here for, and then how that clarity works out in the facts of your case, you may well be right. I mean, I'm not really dug into that. So I tried to look at the restatements, and as far as I can tell, the GRU test is consistent with both the second restatement of torts and the third restatement of torts. It doesn't feel like some weird outlier rule. So what, I mean, you make some good arguments about why it might be unfair to saddle hospitals with the general rule of apparent authority, or ostensible agency as we like to call it, but the restatement calls it apparent authority. But there probably are ways for hospitals to deal with that. Like, you could advise your hospital clients to make sure they communicated to patients when a doctor was not their doctor, right? Why should there be a different rule here when I don't see any cutout in the restatement second or third for hospitals?
I don't think there is a special rule for hospitals. I think in every instance of ostensible agency, it always focuses upon the representation by the principal that created a reasonable belief in the mind of the particular plaintiff, not to the world as a whole, but to the particular plaintiff.
Yes.
That has always been the rule. And what plaintiff is asking you to do is to substitute the reasonable belief requirement with a presumption, a legal presumption that will apply in every case. In every case, because the physician will have been granted privileges and the treatment is in the hospital, there will be no need to establish a subjective belief. And therefore, the rule is not proposing that you go back to the law of ostensible agency as it's always existed. It's asking you to change the law and to substitute the reasonable belief requirement with a legal presumption that then the hospital must negate in order not to be held responsible. But in fact, the hospital and the principal has to create the belief, not to negate a belief created by some other circumstance. It has to be responsible for the information that has led to the belief. And I, getting back to the question of what is a hospital to do, and I think the Michigan Hospital Association, as well as Munson, have addressed the ramifications pretty thoroughly and very persuasively in my view. How is a hospital supposed to do this? Any time a physician begins an encounter with a patient, are they supposed to begin a conversation? Oh, by the way, I think you should know that I'm not an employee of the hospital. I'm an independent contractor. Oh, well, what does that mean, doctor? Well, that means if something should go wrong, the hospital will not be responsible. Oh, well, are there other people in the hospital that perhaps are employed that could treat me instead of you? I mean, can you imagine what what the look of these conversations will be?
What about,
and how?
what about wearing a lab coat that says the name of your practice, like the doctor did in Reeves, as opposed to here where she wore a jacket supposedly that said Beaumont Hospital? Would that be I mean, assuming that's the case, and obviously the factual question of whether she did, or it had both, or she remembered, whatever. But in Reeves, the individual PC, right, was on the jacket. Isn't that a way to perhaps telegraph that you're dealing with, doctors are us as opposed to Beaumont Hospital?
No, because the reality is that usually every doctor in the hospital is identified, the hospital is identified. In this particular case, both of the names were on her credentials, whether it was on her jacket.
Why would Beaumont be on her jacket?
Why?
Why if she's an independent contractor that has no...
I suppose you are correct that they could just have one name versus the other, but then you are relying on the patient to attach significance to one or the other. And again, I will say, if your decision should not rest on that, because in this case, Mrs. Markel does not remember Dr. Lanapin, so she would not remember the credentials or what Dr. Lanapin said when she was introduced. I mean, there are none of the facts.
Yeah, those are all good reasons why you should win, your client should win under the correct test, right? But the restatement third says specifically about inaction, a principal's inaction creates apparent authority when it provides a basis for the third party reasonably to believe that the principal intentionally acquiesces in the agent's representations or actions. Maybe there should be a different rule, but it doesn't say except for hospitals. It just says basically what GRU says, as far as I can tell. Maybe we
Right.
should reject the restatement third. Maybe we should.
I agree with you. It says what GRU says. But listen, intentionally makes the representation. Where is that? Where is the intentional making of the representation? Plaintiff wants you to...
That's not what okay, anyway, go ahead.
Plaintiff wants you to say that the intentional representation exists in the granting of privileges. That's not true. That is not true. There is no way that you can say that privileges are granted to this doctor because I want the world to know that he's my agent and employee.
Can I
So
ask you
would
just
be
a
not being...
factual question? A hospitalist, right? Dr. Lanapin was a hospitalist.
Yes.
Do they practice outside of a hospital in
No.
general? They don't.
She practices within the hospital, and in fact, Ms. Markel testified that she understood that when she went to the hospital, because her primary care physician doesn't go to the hospital, that her primary physician's practice group contracts or has an arrangement, she didn't use the word contracts, but has an arrangement where hospital consultants...
Did she know that at the time she went in, or is that something she subsequently learned?
We have a dispute about that.
Okay.
Mr. Granzato says nobody asked her about the time, and that this is just information she had later. And I disagree with that because it was a line of questioning, asking her about her knowledge of the whole period, while you were in the hospital. So why then suddenly does the question change? And then, but now, what do you know? If you read the context is that it was something she knows about. And in fact, that testimony is consistent with Dr. Lanapin's testimony as to how she came to see this patient, as well as the physician assistant's testimony as to how she came.
Thank you, counsel.
I'm out of time, right?
You are out of time. Do you have one more thing you want to say? I don't want to cut you off.
Pardon?
Do you have one more thing you wanted to tell us? Or you seem so sad.
I'm having so much fun, that's why.
Don't want it to end.
Well, I guess the only thing I would say is that Mr. Granzato was very honest in telling you that if there had been millions of dollars of coverage, I'd probably not be standing here right now. And that's really not a good reason for you to change the law. And it's also really not a good reason for you to change the law so that this particular plaintiff can win. because she can't win under the GRU test. She can't. And so that's why they are asking you to create this legal presumption that would apply in every case to every patient. And jurisprudentially, I don't think that is wise, but beyond that, when you're talking about asking this court to burden the privilege requirement, I say, I'm wondering, as I was thinking about this, where do you even have the authority to do that? Where does this court have the authority to retrospectively impose this burden on a statutory requirement when the legislature didn't intend it? It didn't provide for that. It knew what its purpose was. There's no indication at all that this was the legislature's intent. So where do you have the authority? Respectfully, I say this, of course, you have a lot of authority. And I also think this is not a legal issue. This is a policy issue, as Justice Viviano pointed out. And if you are going to do this, if you are going to impose this burden upon hospitals, it should be done by the legislature. If a deep pocket is what the plaintiffs want, they should go to the legislature and ask the legislature, which can then consider all of the ramifications, all of the legal relationships, all the relationships involved. It's respectfully not for this court to decide.
Thank you, counsel. Mr. Granzato, you're also out of time. The case will be submitted, and I'm fine being mean to you, so.